Now on to our feature presentation today. We are really excited to have our claims manager here at the Trust, Jeff Rowley, here to talk to us about liability claims in local governments. And I think you got something to talk about our notice of claim process and updates on that. We'll turn the time over to Jeff if he wants to take the screen and get all of the information he has to share with us.
Good morning, everybody. I'm glad to be here with you. I just want to review a few things and some updates the legislature has made. I'm glad to just visit with you and talk about claims, in particular the initial process and the notice of claim process as outlined in state law, and would like to just run through that a little bit, what protections you have and why that we have what's called the notice of claim. To get started, though, I would like to ask a question, as Jason said I would. What risks keep you up at night? When you think about how your entity operates and what damages or injuries you may cause to somebody else, what worries you about that? What kinds of things could happen that bother you? So throw that in the chat if you would. And while you're thinking about all these nightmarish things that could happen in your organization, I'm just going to do a quick shout out to our loss prevention services that are provided by Jason and Mike. They do a great job. I've been in public entity risk management for over 30 years now, and most of that time I was struggling to provide my own loss prevention services. Could never duplicate what these guys provide for you and what the Trust provides, including these other webinars and seminars that we do. I'd like to particularly highlight our Trust Legal Brief series. We have one coming up in a couple of days on water and sewer losses. That'll be a good one to do online, better not in person for that stinky topic. But September, we're going to talk about police lawsuits and Section 1983 cases. These are taught by an attorney. They are not recorded. Because the attorney said, the law could change quickly and I don't want to be on record and have something go out of date. But these are so valuable and pertinent to everything that you do. So want to get a shout out for that in particular, the Trust Legal Brief series. And then finally, if you don't have these, we've put them up in the chat so you can download these Trust Services cards. And in particular is the legal hotline. This service is highly used and is super valuable. If you have something that's gone down and it's gone down bad, you can call the legal hotline for some advice. If you're thinking about changing the way you're doing things and having a novel approach to doing something, I recommend you call the hotline. Make sure that you're doing that within the legal confines. Anything in between there, it's a free service for you. How it works, you call in. Our CEO matches the question to one of our attorneys and connects you with them. You talk about it. If you need more resources beyond that first free call, you can hire the attorney, but you hire them at the Trust deeply discounted rate to help you with that. So it's a great service for our members. So what do we have in the chat? Anybody put in there things they're worried about? What keeps them up at night?
Yeah, Jeff, Linda says playgrounds.
Oh. Yes.
Kendall says pipe break flood risk.
Oh, well, that never happens, right?
Patrick says all of the utilities.
All of the utilities. Yes, we have members that provide electricity too. Those things can create great risks, whether it's property damage or bodily injury including death, and bringing up playgrounds. Oh boy, that's certainly something that we worry about there. Well, let's talk a minute about governments. Why we do what we do. In this country, we want government by the people and for the people, and so that we protect our rights. But a lot of the things that governments do really can only be done by governments because we as government entities oftentimes administer people's rights that are guaranteed under the Constitution. We can't leave that to a private entity. We need the government that represents all of us. Also, much of what we do is so costly to manage and maintain that there's no way that it could be done if it wasn't done by all of the people. And so we build roads and bridges, we do all kinds of things that, you know, a community, a street couldn't do by themselves for their street even. And then because the risks involved with some of the things we do are just simply too great, that you couldn't do that in the private sector. Recognizing all of these factors are that we want our rights protected, the costs and the great risks associated with these things, government has some protections that we build in. And so government goes out there and we build roads, we build infrastructure for our transportation systems. And then what do? We come along afterwards and we cut those streets up to add new pipes or replace pipes that are broken. All of that's very costly and very risky. And so we are protected in Utah under what's called the Utah Governmental Immunity Act. This flows out of old English doctrine that the king can do no wrong. We, of course, don't have any kings, and we don't necessarily think that they can do no wrong. But because government takes on such great risks on all of our behalf, we have created an immunity act that protects us based upon the values that we hold as a nation, and in particular as the state of Utah. These protections under the Governmental Immunity Act are almost always under attack in the courts and at the legislature. And in fact, right now, there are at least 2 cases that are either at or on their way to the Utah Supreme Court challenging either sections of the act or the entire Immunity Act itself. And if the courts find that the Governmental Immunity Act is unconstitutional, that will drastically change the landscape for us as government entities and what the costs are. Right now, we have protections, and I'm going to talk about those protections in a minute, that says we don't have to pay for certain claims. Well, imagine if those protections are gone and all of a sudden we have to pay for everything that happens, whether we're negligent or not. Our taxes are high now, but they will significantly increase if that ever happens. So let's talk about the act and what it does. It essentially has 3 veins or 3 different areas that it protects us. All of these are protections. First, it creates a pathway to the courts. And we're going to talk a lot about that today because that's what's changed this last legislative session. Secondly, the Immunity Act protects us from certain causes of action. Now, let me give you a caveat that the Governmental Immunity Act only applies to state law claims and not to constitutional claims. So if there's a civil rights violation, that's not protected by the Governmental Immunity Act, or violations under federal law, like under FMLA or the ADA, those aren't under the Governmental Immunity Act. So that's outside of that. But by and large, the claims that come against us as local government entities fall within the protections and guidelines set out by the Immunity Act. And I like to think of it as a picket fence because most things get stopped by the Immunity Act. You can't sue us for this, or you can sue, but you can't win if you decide to sue unless you do these things or for this kind of activity that the government engages in. For instance, we are immune and they can't prevail in a lawsuit against us for the management of floodwaters or the management of an epidemic. We have total immunity for that. Also, we're immune for inspections and permits that we give out, or for riots and civil commotions. We're immune from natural conditions on our open space land. So for instance, if you have some undeveloped land that the city owns, maybe interface with the hillside, and on that hill, there's a great cliff that people have found is a good one for climbing and rappelling. And so they go and they climb and rappel, and if they fall because the rock gives away, if that land is left by you in its natural condition, you didn't develop it, you didn't create the climbing routes, those sorts of things, you have immunity for anything that happens on the land that's still in its natural state. Also, you're immune from latent defects in our infrastructure. What do I mean by latent defects? Well, let me give an example. Let's say, every summer, generally we hear of a place on I-15 where the concrete during a really hot day has exploded and therefore causing damage to vehicles. Well, what caused that to explode is the heat and probably some defect in the concrete that we couldn't have identified or known about. And so we have immunity for that. And then finally, under the Governmental Immunity Act, it limits how much judgments can be issued for us or against us. For instance, if you have one person injured in an event, the most they can get right now, and this changes every even year, the most they can get is $911,300. If more than one person is injured, let's say you've got a car full of people and we strike them with our vehicle, there's a per occurrence limit of $3,668,400. That's the most, no matter how many people are in that accident. And then for property damage, the limit is $366,900. So if your garbage truck turns a corner and accidentally runs over a brand new Aston Martin Vanquish, which costs $550,000, they're not going to get that amount. It's going to be down in the 300 range, down to the Governmental Immunity Act limit for property damage. So the Governmental Immunity Act does those three things to protect us as public entities. So let's talk about the claims situation. When things go bad, how do you handle them? And really, your initial response can be very key in certain circumstances. And when you go to the scene of an accident, let's say you have a broken water line in your street, you really need to think about these things as being two parts. First, your initial response. How do you deal with what happens on scene? You shut the water off, you restore the services, you tow your vehicle away, you make the scene safe, you engage emergency services. Those are all important and they need to be done right. You should talk about those in advance. Who's going to be your tow company? Do we have good maps in our trucks so that we know how to shut the water off or divert sewer? How do we do all that? But also, and sometimes in big enough situations, you may actually want to have two teams, a response team and another team, or a second thing that you're considering on scene is how do you prepare for the aftermath? And it's a good idea when you have an event where you've damaged somebody else or multiple somebody's else to always think ahead that this will turn into a lawsuit, and how do I plan for that? That's just a great mindset. Many of them do not turn into lawsuits. Many of them do turn into at least claims. And you start your preparation for the claim or lawsuit right there at the scene. So I'm going to give you some do's and don'ts that I have found over the years are very helpful in preparing for whatever the aftermath is from these untoward events. First of all, do identify the cause. Of course, that's what you're going to be do, but that takes some time. Follow your policies while you're on scene. So in other words, in advance, talk about who goes out, who can speak to the media, what do you say to the other parties while you're there on scene. Practice these things, put them in policy, get people out there that have the know-how to do that. Train your employees as to what they say. Do document the facts, take statements and reports, take lots of photos, take lots of videos. They're free, take them from different angles. You just never know which one is going to be valuable in establishing the facts of the accident. So be copious in the amount of photos and videos that you take. Do communicate the next steps to affected parties. And that may be that here's a notice of claim form, or call our office to get a notice of claim form, and that starts the process. But there might be more to it. For instance, in a sewer or water backup situation, you've got a lot of people that have suffered and they're just overwhelmed, don't know what to do. In that particular case, we have a protocol that we've written up, and it's attached to the presentation here today, so you can download it from the chat site, of things to do right on scene immediately, what to communicate to these people, and then what they can expect from us once you've communicated it back to us so that the claim is started. And do, for sure, preserve evidence. There's a legal doctrine called spoliation. Essentially, if there is evidence needed in a court hearing or a trial, and that evidence is not available because the party that should have had it got rid of it or something, the courts are then to infer that any facts or conclusions that could have come from that evidence that is no longer there would be in favor of the other party and against the party that should have had the evidence. So they infer negativity against you. Let's take an example of a car in a car accident. If you expect a lawsuit and you're going to destroy that car, you might want to wait before you get rid of that car to make sure that it's safe, that the other party is not going to be asking to get a hold of the data recorder, take more photos of their own. Or if you have a pipe that broke that caused all kinds of damages, save the pipe. After you've cut it out and you're putting the new one in, don't just toss the old broken pipe. That may be crucial. And there have been some public entities in the state that have suffered because they haven't had that and ended up paying more or paying when they probably shouldn't have, just because the evidence at the scene was destroyed when they should have preserved it for a future lawsuit. So once you've gotten past the scene, you need to file a claim. And under the Utah Governmental Immunity Act, there is what's called the notice of claim process, which begins everything. And it's how you report it to the trust, although you can report it before a notice of claim is filed, and we can talk about that. But our hope for you is that you get claims to us as quickly as possible so that we can take over. We establish that we are the aggrieved or damaged party's contact in this and leave you off on the sides as much as possible. Let us be the bad guys. Let us be the communicators. Keep you out of it so you can go on doing your important work for your community. So pass that along to us as quick as you can. Here's what happens when you file a claim. And we're talking about liability claims here, first of all, but we'll talk about other claims for just a moment. First, once you file a claim with the trust, that claim will be set up, usually same day. A claims professional will be assigned within that same day, next business day, and then it's their obligation to reach out to you, and where appropriate, to reach out to the claimant within one business day. So it's our aim to get right out there, get the communication started with you and with these parties that have been damaged as quickly as possible. That helps to calm the situation down. Our claims professionals are trained to identify what next steps are and set expectations so that people know that they can't just immediately get resolution. Because it's a liability situation, we answer two questions. Who's at fault? And then what are the damages? We can't lead with taking care of the damages until we know who's at fault. But our adjusters also inform people, look, you have homeowners insurance or autos insurance or health insurance. Go to them first, make a claim with them if you need help immediately, because we're not in a position to respond as fast as they want in many cases. So it's a good idea to let them know, and we will do that they can contact their own insurance carrier. Well, let's pause for a moment and let's talk about who's Constitution State Services. That is a big question. Yes.
Maybe we'd answer this question before you move on. We had Patrick ask, what if the accident results in a fatality?
I guess I'm not sure what specifically about that you asked, because it's not a lot is different there. And in a fatality, obviously the idea and the hope is that things get taken care of quickly. But in that case, it's very clear that we need to know all the details before we can respond. Perhaps the question is it okay to express sympathy? Oh, yeah. It doesn't even have to be a fatality. If you're in an accident, man, I'm sorry this happened. That's okay to say. We're people. We want to be compassionate. But saying, gee, I'm sorry I hit you, that's different than saying, I'm sorry this happened. Or, man, I screwed up back there. That's not a good thing to say right away. But certainly you can share compassion for what's going on immediately after an accident. and you can express, hey, we'll get this to our insurance carrier as quick as possible. They'll report to you or call you as quick as possible as well, and lay out what you can expect. That's not my role. I'm just here to gather facts. And people get that. I mean, you're at the scene. You're not going to know everything. So hopefully I've answered that question, Patrick. If not, you can follow up with another question on that. Any others I should answer right now, Jason?
I think that Patrick came back maybe with the specific example, but maybe for later in the discussion. But in short, it puts an nothing changes, but it puts an exclamation point on the process.
Yes, and I was kind of expecting somebody to use that as an example of what they worry about at nighttime, because it does happen. And we've got lots of experience in dealing with those situations. Again, get us involved ASAP in that process. Well, we are the Utah Local Governments Trust. We are not an insurance carrier, and we are not regulated by the insurance department. We're set up as a government entity, as a government entity risk pool where you pay into us. We, on a no-profit basis, manage your risks and pay claims on your behalf. So we are your insurance carrier, but we found several years ago that we can do better in how we process claims for you. And so we contracted with Constitution State Services, which is a division of Travelers Insurance, to manage our claims for us on a day-to-day basis. Travelers is not the carrier, we're the carrier. We just take advantage of all of their resources and all of their experience in handling claims and lawsuits to do that for us. So once a claim is filed, you'll be hearing from somebody from Constitution State Services. So I just wanted to make sure that everybody knew that they are our representative, but we are the party that pays the claims. Also, I mentioned that you're filing of a notice of claim. Well, what is a notice of claim? And let's dive into that for a few minutes. Under statute, it says any person having a claim against a governmental entity or against the governmental entity's employees for an act or omission occurring during the performance of the employee's duties within the scope of employment or under the color of authority shall file a written notice of claim with the entity before maintaining an action. So it's something that a person who's been damaged files in written form, and it's filed with you, the public entity, not with the trust. It's to go to you. And the notice of claim is essentially what is called a threshold requirement. In this case, it says compliance with the Governmental Immunity Act, that's GIA, is a prerequisite for vesting a district court with subject matter jurisdiction over claims against public entities. So where a notice of claim is required, if one is not filed, the courts don't even have jurisdiction to handle a lawsuit should it be filed down the road some ways. And so it's a threshold requirement. Well, what is a notice of claim? It's a written statement containing these things: brief statement of the facts, who it is that's making the claim and what damages they have. The notice of claim is to be filed with the public entity, as I mentioned, and state law kind of defines who should get it. For a city and town, it's a recorder. For a county, it's a clerk. For your other districts, you can just designate somebody there, plus your attorney should receive them. A notice of claim can be hand-delivered. It can be sent in by mail, or it can be sent in by email. And under state law, and this has been in place for a while now, if it's sent by email, it has to be sent to the designated agent, the clerk or recorder, and to your attorney, both. Otherwise, it doesn't comply with the statute. And when must it be filed? It must be filed within 1 year after the claim arises. So for government entities, we have a shortened statute of limitation. They have to get it in within 1 year of the date of loss, or else they don't have a claim. So why is the notice of claim important? Another case said its primary purpose is to afford the responsible public authorities an opportunity to pursue a proper and timely investigation of the merits of a claim and to arrive at a timely settlement, if appropriate, thereby avoiding the expenditure of public revenue for costly and unnecessary litigation. So its purpose is to help us get these things taken care of in a timely manner. Now, we have some attorneys who have interpreted the act to say, well, a notice of claim is required before a lawsuit is filed, but that doesn't mean we can't respond to the claim and even settle claims without a notice of claim. Well, the problem with that in our experience is that we don't always know which ones will go to a lawsuit. So when do you send the notice of claim? When do you require it? We found as our best practice to do a notice of claim immediately up front. Now, that doesn't mean that if you have a drastic situation that we won't respond to claims before the notice of claim comes in. In fact, we will. If you have something that needs to be addressed right away to give people comfort and know what's next steps, call the claim in, but at the same time, make sure you give that notice of claim form to the parties that are making these claims. Tell them to fill it out and get it back to you as quick as possible. And in the meantime, the claim will proceed. We'll do our investigation, but our adjusters are trained that they can go as far as coming to the point where they can settle, but they can't settle without the notice of claim. So it's a key protection. If they don't file the notice of claim, they can't sue. If they don't file it within 1 year, they have no claim. So it is truly one of the great protections in the Governmental Immunity Act that we should all rely on. While the law may be complicated about the notice of claim process, it doesn't have to be a complicated process itself. So here's what we suggest. Create your own notice of claim form that has all of the elements in the statute, or you can use the draft notice of claim form that we can send you if you don't have one already. Also, send your form out to anyone that you think may be wanting to make a claim. A caveat there is you don't need to send a notice of claim to an attorney or to an insurance company. They generally don't use our forms anyway, and they know the process. And doing so would essentially be giving them legal advice. So we don't need to do that. But for individuals, get that notice of claim out to them. When the claim comes back to you, don't worry about whether it's compliant with the law. Just forward it on to us immediately. And one of the methods for filing claims is listed right here. You can forward it by email. And since you're dealing with a document, that's really the easiest way. You can call a claim in, you can email it, or you can go online and put all the data into our database. But for notices of claim, since they're in paper form, I found, and most members find, that it's just easiest to email it in and you're done. You don't have to spend any time putting anything into the system yourself. Well, here's a sample of our notice of claim form. It has instructions up front that identifies the law, identifies how important it is, who the claim should be sent to, and gives a little bit about Medicare and Medicare obligations, and then defines who it is that is supposed to receive the claim. Now, when we send you a draft, you'll notice it has entity logo up here, entity name. Those are keys and guidance to help you know. Fill those in with your name on it. Don't get the notice of claim form and just send it out with entity logo still written at the top. Own it. Make it yours. Put your pretty logo on there. Put your name on there. Make sure for sure you put in there who it is that is supposed to receive that notice of claim, and you're good to go from that point on. Now, what changed for this year? There was a slight change to another element of the notice of claim process, and that is that each governmental entity is to file a statement with the Department of Commerce, and that goes on to what's called the Governmental Immunity Act database. For years, the plaintiffs' attorneys complained that they just never knew where to send a notice of claim in or who to sue when governments were involved. So the legislature created this database where we have an obligation as public entities to post who it is that's supposed to receive claims for our entities and what that address is, what the email addresses are for those that receive those claims. And there were some changes this year to that. And that was under Senate Bill 169, which says specifically, it requires a governmental entity to file a statement with the Division of Corporations and Commerce and Code containing any doing business as name. So if you have a DBA for your organization, that needs to be listed on there. And the office and agent designated to receive a summons and complaint, and the physical address where the summons and complaint is to be received. In the past, it was just who is to receive a notice of claim. Now we need to affirm on there who it is that's supposed to receive a lawsuit. And if you have a DBA name, so that they make sure they get it to the right entities. Also, the bill says specifically, if public entities don't comply with this law, don't have this statement up there, then they can't complain when a lawsuit is filed that it was untimely or that the notice of claim wasn't done correctly, because we failed to do our part of notifying the public where claims should go to by filling in this statement online. Here is the database. It's again on the Department of Commerce website. The web address is up here. Anybody can go in here and type in your entity name, like Utah Local Governments Trust. We're a special service district, and hit search, and it'll pull up the information that we have filed with there. But now they've just barely updated this database with this new button here. You click that button if you need to update it, and you download one of these forms. Either you've never done it before, you don't have an entry on the database, you use the new form, or if you're just changing or updating it. I don't know why there's two forms, because they're almost exactly identical in what you have to put in there to fill out the form. But you just download these PDF forms, fill them in. Here's an example of one, and email it back, and you're done. So it's a pretty simple process. What you need to do in advance is identify who it is that's supposed to receive it, and your attorney's information, and just submit the form, and you're done. So how do you update the database? Designate the officers. Have the following information at hand: your DBA, who's your designated agent, your clerk, your recorder, the address where it's to go, and the email address for the agent and for your attorney. And that's it. And just submit it in there. So that's the change that happened this year. Again, it's critical that we update this database. Otherwise, we lose the protections that come through the notice of claim process. And if we've done this and they don't file a notice of claim in a timely way, then the courts don't have a case. I handled one for one of our Utah County members a few years ago that could have ended up with a case where they were demanding upfront $400,000 from an attorney. But that attorney never filed the notice of claim with the entity that was involved before they filed suit. And the time ran out, and the court said, "I'm sorry, you don't have a notice of claim, you're gone." Now, that's kind of sad, because somebody was injured because of this accident, and it was the government entity's fault, but they didn't comply with the law, and so they didn't have a claim against that entity, that is. Of course, they had a legal malpractice claim that they could make. So that's the change. Have a notice of claim form, instruct your people on how to use it, and then update the database when you have changes in personnel. Think about it when elections happen and you get new people in place. Update that, keep that up to date, and you're good to go. Just wanted to point out, these are the ways that you can file a claim with us. You can send it by email, as we talked about before, by phone, or online. And these are listed on that trust services card that's attached in the chat for you. Or if you have property coverage with us and you have crime, cyber, or a pollution claim, just call me and I will get those claims started for you right away. Claims are, a part of doing business, but they're not a pleasant part of doing business. It's our intent and our hope that when they do happen, that we can help resolve them as quickly as possible on your behalf, and keep you as far away from it as possible, so that you can do what you set out to do and what your public purpose is. So get claims into us right away. Call the Trust Legal Hotline, or call me if you just don't know what to happen. And if you have a big scenario, you have a fire, you have a sewer or water backup, multiple vehicles involved in an accident, you're like, oh my gosh, we need help right away, give me a call. I'll help get the ball rolling on your behalf as quick as possible. So thank you for your membership in the trust.